is in court, my lord. Defendant absent.
Registrar, call 14, call LKJ 14 first.
Okay, my lord. NICN LKJ 14 2021 between Eneu Musa and Bulletin Construction Company Limited. Claimant is in court, my lord.
Defendants absent.
Yes, my lord.
Appearances.
May it please me, Lord, I'm P. Amen. I appear for the claimant.
Any other appearance? Any appearance for the defendant?
The defense counsel is online. He didn't connect with the audio. Damian.
I can see him, but I can't hear him. Learned counsel, Damian.
My lord, he didn't connect with his
Learned
audio.
counsel. And he's not in the courtroom. Okay. The judgment is ready. I'll go ahead and deliver it. Here is the judgment of the court. By a general form of complaint, dated and filed on the 3rd of November 2021, the claimant commenced this action wherein he claims against the defendant as follows. 1, the sum of 388,500 naira as outstanding balance of his entitlement at Dobi site, Niger State in 2009, and Nakuse site, Nasarawa State in 2010. 2, the sum of 415,000 naira as his retirement benefit after working for 14 years with the defendant. And 3, the sum of 1 million naira as the general damages. It is the claimant's case that he was an employee of the defendant as a roller operator, Lokoja, from the 4th of March 2001 to sometimes in March 2015, though no appointment letter was issued to him when he started working, but he was given an identity card. He averred that he has spent years and months in the different states working for the defendant, rating from the year 2001 to 2015 before his appointment was terminated by a general stood-off that sent everyone away in the month of March 2015. He continued that his monthly pay is 54,500 naira. But he is also entitled to some outstanding balance of salaries and entitlements to the tune of 184,000 while serving at Dubi site, Niger State, and Nakuse site in Nasarawa State between 2009 to 2012. He stated that by virtue of working for the defendant for a period of 14 years and the period of his stood-off, is entitled to the payment of 415,000 naira as stated in the staff handbook of the defendant. The defendant in its defense stated that claimant was not a permanent staff, but a contract staff who occasionally worked for the defendant at different construction sites whenever the need arises, but contended that at no point did the claimant work for the defendant for a continuous period from March 2001 to March 2015. It averred further that claimant was recruited in Abaji when the defendant was awarded the contract for the dualization of Abaji Lokoja route and was not issued identification card to enable him have access to the construction site. It continued that it only transfers permanent staff with the duly issued transfer letters, but does not transfer contract or casual staff whose duties starts and ends at every construction site. However, when the federal government could no longer fund the dualization of Abaji Lokoja route, and the claimant not being one of the staff stood off, he absconded from the defendant's employment in September 2014 and have never been seen to date. It was asserted further that claimant was paid all his entitlement up to September 2014 when he last worked for the defendant, and that the claimant is not entitled to the benefits of the terms and conditions contained in the staff handbook, as it is only applicable to permanent staff. The defendant equally responded to the claimant's action by way of a counterclaim, wherein it asserted that between 1st October 2014 and 30th October, when the claimant defendant to counterclaim absconded from work, he was not entitled to collect salary or allowances from the defendant counterclaimant, but its account department paid October 2014 salary. And allowances to the claimant in error, not knowing that the claimant never worked for the defendant in the said month, and that the claimant defendant to counterclaim, knowing this, still retained the money. Hence, the defendant counterclaims against the claimant defendant to the counterclaim as follows. A, the last month pay of 54,000 naira covering October 2014, a rentals paid to the claimant was no longer in the employment of the defendant. B, the defendant counterclaimant claims from the claimant defendant to the counterclaim the sum of 500,000 naira general damages for the period the money stayed with the claimant, which could have been effectively utilized to yield more than the said 500,000 naira. The claimant defendant to counterclaim filed a reply to the counterclaim, and he emphasized that he was the ruler operator for the claimant from 4th March 2001 and was only disengaged in 2015 and did not at any time abscond from the defendant counterclaimant's employment in September 2014, and that he was paid October 2014 salary and allowances because in that month he worked for a while in the employment of the defendant Hence, he was entitled to eat. He averred that he was still in the employment with the defendant counterclaimant in 2015 because he was paid some of the salaries and allowances in 2015 before they stood up that disengaged him. On the
No.
My lord, the audio is cut off.
Sorry, I can see now that you didn't hear me. So which part I can see my system was muted. Well, I'm still at the preliminary stage. So I'll go over this part. Can you hear now?
Yes, my lord.
Okay, on the 14th of March 2020, parties intimated the court of their voluntary consent to adopt the argument of record procedure pursuant to Order 38, Rule 33 of the rules of this court. And by this procedure, parties have consented to dispense with the need for oral hearing. And the case is to be decided based on the pleadings, written witness statements, and documents front-loaded by parties before this court. In compliance with the order of the court, parties filed their final written addresses, and I've reduced that into the body of this judgment. So I'll go straight to the decision of the court. After a careful perusal of the facts of this case as presented by parties, the processes filed, exhibit tendered in support of each party's case, and the submission of both learned counsel. In this case, I am of the firm view that two issues, the determination of which will make the justice of this case are, one, whether the claimant is entitled to the relief sought, and two, whether the counterclaimant has proven its case to be entitled to the relief sought in the counterclaim. On the preliminary, I find it germane to address certain issues that arose in the pleadings of parties in this case. The defendant, by paragraph 17 of its statement of defense, averred that it shall, during trial, rely on all available remedy, including the fact that the suit is an abuse of court process, incompetent, speculative, and that this court lacks the territorial jurisdiction to entertain this case. However, during trial, and up to the filing of the final written address of the defendant, learned counsel on behalf of the defendant failed to address the court on these points of law. On the point of law raised in its pleadings as to the competence of the matter and the jurisdiction of this court to entertain this case. The Apex Court held in the case of Tourist Company Nigeria Limited and Neo Vista Properties Limited, citation captured, that any issue raised by a party on which no argument is preferred is deemed abandoned. See also the case of FRN versus Emirates Airlines, citation captured, Abalakan Minister of Health, and other citation provided. Learned Defense Counsel, in its infinite wisdom, did not prefer any argument for the issue raised at paragraph 17 of the statement of defense by failing to address the court on those points of law, abandons him, and is equally deemed to have conceded that the matter be tried on the merits and on the strength of the facts pleaded in its pleadings. It is the contention of the Learned Defense Counsel in its final address that the documents annexed to the claimant's process were in short of legal requirement. In his contention, he stated that the claimant relied on an uncertified true copy of the first bank statement of account and therefore inadmissible. He equally submitted that the purported bank statement relied upon did not meet the standard provided for in section 84, subsection 4 of the Evidence Act, and that there was no certificate of compliance attached to it. The submission of learned counsel is misplaced and misconceived. First, in the sense that there is no provision in any law that provides for certification of a statement of account to make it admissible. Also, the position of the law as to admissibility of certified true copy is clear, and it is to the effect that only a photocopy of a public document needs certification to be admissible as secondary evidence, and which is to ascertain the authenticity of such public documents. See section 104 of the Evidence Act and the cases of Emmanuel and Mana and other citation provided. The case of Goodwill and Trust Investment Limited and another versus Wheat and Bush Limited, citation also provided. Unarguably, the statement of account of First Bank is not public document by virtue of section 102 of the Evidence Act to require that it be certified in accordance with the provision of section 104, subsection 1 and 2, sections 1, 2, and 3 of the Evidence Act before it can be admissible. Besides, the requirement of certification of public document is for the purpose of admissibility of the evidence during trial, and which is not obtainable in this case, as there is no oral hearing that would necessitate admitting the documents. Thus, reliance on section 104 of the Evidence Act is misconceived. It is also the grudge of learned counsel that the purported bank statement relied upon did not meet the standard provided in section 84.4 of the Evidence Act, and that there was no certificate of compliance attached. it needs to be stated that Section 84 of the evidence are relied upon govern admissibility of computer-generated evidence during trial. The question of admissibility does not arise in this instance because the case at hand was tried on record, dispensing with the need to with the need to call oral evidence during which the question of admissibility of documents will arise. This is because really consented to and adopted the argument on record procedure by Order 38 or 33 of the rules of this court, which is to the effect that parties have dispensed with oral hearing of the case and consented that the case be decided on record. Learned counsel himself consented to the argument on record procedure, which means that he wants the court to try the case based on the pleadings and documents front-loaded. So even if the said statement of account were to be a public document, which is not the case in this instance, the said statement of account will still be relied on by this court because of the special procedure adopted by parties in this case. Learned counsel equally contended that the schedule of the defendant's salaries allowances is inadmissible, being photocopies and unsigned by any director of the company. I perused the processes filed by the claimant in this case, including all the documents relied upon, as well as those front-loaded and the originals forwarded to the court by the claimant, and I cannot find anywhere where claimant hearing placed any schedule of payment before the court, even though the purported schedule was one of the documents listed in claimant's list of documents. Claimant in this case did not place any schedule, whether photocopy or whatever, before the court, contrary to the assertion of learned defense counsel. It is my view that learned counsel clearly misconceived the exhibits relied on by claimant in this case with those relied upon by the claimant in the sister case in suit number NICN/LKG/13/2021, wherein the claimant relied on the schedule of payment. Assuming claimant even placed any photocopy of the schedule before this court as alleged by learned counsel, the defendant has impliedly waived its right to complain about any of the front-loaded documents when it consented to the argument on record procedure, urging the court to decide the case based on the pleadings of parties and documents front-loaded without prior filing of any schedule, stating that it objected to any of the documents front-loaded by the claimant. It is equally the contention of learned counsel that the condition of service relied on by claimant is a photocopy and was equally not signed and as such worthless. First, let me say that claimant in this case merely pleaded the staff handbook, which represents the condition of service, but did not front-load same. He didn't front-load it along with other documents relied upon. Learned counsel on his behalf, however, attached a copy of the staff handbook of the defendant along with his final written address, and which is the same as the one front-loaded by the defendant in this case. In view of the special procedure adopted in this case and in the pursuit of substantial justice, this court will take the said staff handbook as properly filed before the court, even though it was not front-loaded. Now, let me address the contention. Just a minute, please. There's no light in Abuja, so I can't. Just a minute. Open the windows. In view of the special procedure adopted in this case and in the pursuit of substantial justice, this court will take the staff handbook as properly filed before the court, even though it was not front-loaded. Now, let me address the contention of counsel as to the staff handbook being a photocopy and unsigned. By the special procedure adopted in this case, the court is to rely on documents front-loaded. And as I've reasoned supra, it is photocopies of documents that are usually front-loaded, except where a party has a document in counterparts or specifically requested for the original copy, which is not the case here. Thus, it is not surprising that what the court will consider in this case is a photocopy of the condition of service front-loaded. On the second issue regarding an unsigned condition of service, There is no law that requires that a condition of service must be signed before it is admissible. The position of the law is settled on whether or not a condition of service should be dated or signed. This was well captured by the Honorable, the President of this court, B.B. Kanyip, in the case of Roslyn Ekeng versus International Energy Insurance PLC, is an unreported suit number NICN/LA/2022/2016, a judgment that was delivered on 18 June 2019. His Lordship, when faced with a similar issue, aptly put it thus, I quote, "As a staff handbook, it is the condition of service of a defendant, and conditions of service are most often not signed or even dated in the manner canvassed by the defendant. Employees are also not required to sign condition of service. In other words, the applicability of conditions of service or staff handbook is not dependent on their being dated or signed by either the employer and or the employee. This being so, the argument of a defendant in this regard goes to no issue and so is hereby rejected," unquote. See also the decision of this court in the case of Dominica Ogadima Abi and SEC Equipment and Communications Nigeria Limited, is an unreported suit number NICN/ABJ/388/2020, judgment that was delivered by my humble self on the 13th of October 2021. It is in the light of the decisions in the above cases and other line of case law authorities that I find that a condition of service does not have to be signed. More so, by the provision of Order 15 Rule 3A and B of the National Industrial Court of Nigeria Civil Procedure Rules 2017, where defendant respondent is served with a scheduled list of documents or any recording by an electronic device to be relied on at trial by the claimant in compliance with Order 3, Rule 9 and 10 of the NIC rules. The defendant shall file and serve along with the defense a schedule that indicates documents not objected to and another schedule that will indicate documents objected to. Order 15 Rule 4 of the rules of this court provides for that any document or recording by an electronic device contained in the schedule which is not objected to by the defendant shall be deemed admitted, except the court otherwise directs. The defendant did not file any such schedule objecting to any document in this case. They are thus deemed to have admitted those documents and cannot at this stage be raising the question of admissibility of those documents, especially where the procedure adopted by consent of parties in this case is a special one. The point needs to be made that the law is settled that a party who has consented to a particular procedure adopted by court cannot turn around, complain or say that it worked injustice against him. See the case of NNPC versus PIF and others citation captured, the case of Lasisi and Lokoja and others citation captured. It is in the light of the above that I discountenance the objection of the defendant to the documents relied on by the claimant. Now to issue 1. It is a claimant case that it was a former employee of the defendant who worked as a rural operator from the 4th of March 2001 to March 2015. Claimant in proof of his case relied on a staff identity card. In a contract of employment, the general principle is that the letter of appointment must be tendered as it is the document that the court look at in considering the rights and obligation of parties. See the case of, Organ and Others versus NLNG citation provided. The case of Morumfola and Kwara State College of Technology citation captured. Although the general principle is that the letter of appointment is the bedrock upon which a claimant in an action for wrongful termination of employment must build his case. The application of a general principle must necessarily depend on the pleadings, the evidence led, and the issues which call for determination in a particular case. Therefore, ordinarily, an employee ought to tender his letter of employment. See the case of Unity Bank and Corey, citation captured, the case of Mobile Producing Nigeria Unlimited, and another versus Udo, citation provided. However, it should be noted that claimant by his statement of facts, specifically by paragraph 3 thereof, stated that he was not given a letter of employment, but was issued with an identity card. The defendant, in response to the said averment, only stated by paragraph 4 of his statement of defense that he admitted paragraph 3 of the claimant's statement of fact, only to the extent that claimant was employed in Abaji for Abaji dualization and was issued with staff identity card. The law is settled that a defendant must specifically answer to every allegation of fact made in the claimant's statement of claim or facts. The defendant ought to frankly admit or deny the specific part of claimant's affirmation in paragraph 3 of his statement of fact as it relates to the non-issuance of a letter of employment. In the case of Nwokoro and Unuma citation captured, the Supreme Court per Y4 GSC held us, and I quote, general traverse is convenient and permissible when dealing with a long and complicated statement of claim to cover all the allegations which are more or less immaterial and those allegations of which counsel has no instruction. But it should not be adopted in dealing with the allegations which are the gist of the action. The better approach is that to such allegations, the defendant should plead as precisely as possible, unquote. Failure of the defendant in this case to either frankly admit or boldly deny the claimant's assertion as to the specific averment of non-issuance of letter of employment to him by the defendant is an admission of that portion of claimant's averment. The evasive averment or response of the respondent as to the non-issuance of a letter of employment can answer for the specific averment of claimant as to non-issuance of a letter of employment is thus taken as an admission. I will take that again. The evasive averment or response of the defendant as to the non-issuance of a letter of employment cannot answer for the specific averment of claimant as to non-issuance of a letter of employment and is thus taken as an admission. See the cases of Polaris Bank Limited and Atogun, citation captured, Baruko and Baruko citation provided, Attorney General of Anambra State and Onu Selugo Enterprises Limited citation provided. Thus, it is taken as proved that the defendant did not issue claimant with any letter of employment. It is important I state at this stage that the Labor Act, Cap L1, Laws of Federation of Nigeria 2004, hereinafter referred to as the Act, is a primary legislation with the framework of labor relation in Nigeria and the principal law that governs labor-related matters and the relationship between employers and employees. The Act goes on in Section 91 to define who a worker is, and it states that a worker is any person who has entered into or works under a contract with an employer, whether the contract is for manual labor or clerical work, or is express or implied, or oral or written, and whether the contract is a contract of service or contract personally to execute any work or labor, but does not include anyone exercising administrative or executive, technical or professional functions as public officers or otherwise, or members of employers' family, representatives, agents, and commercial travelers, insofar as their work is carried on outside the employer's permanent place of business. Any person who is given articles or materials to make up, clean, wash, altered, and ornamental, required, repaired, or adapted for sale in his own home or on other premises not under the control of the person who gave out the article or material, and any person employed in a vessel or aircraft to which the laws of merchant shipping or civil aviation applies, unquote. See also the case of Shina Security Company Limited and Afropac Nigeria Limited and others, citation captured. From the above provision of the Act, the claimant who worked in as a roller operator, which is a form of manual labor, qualifies as a worker under Section 91 of the Act. The Act also imposes a statutory obligation on the employer as regards terms of employment, as regards issuance of a term of employment. Section 7 of the Act provides thus, and I quote, not later than 3 months after the beginning of a worker's period of employment with an employer, the employer shall give to the worker a written statement specifying A, the terms of the employer or group of employers, and where appropriate, of the undertaking by which the worker is employed. B, the name and address of the worker and the place and date of his employment. C, the nature of the employment. D, if the contract is for a fixed term, the date when the contract expires. E, the appropriate period of notice to be given by the party wishing to terminate the contract, due regard being had to Section 11 of this Act. F, the rates of wages and method of calculation thereof, and the manner and periodicity of payment of wages. G, any terms and conditions relating to 1, hours of work, or 2, holidays and holiday pay, or 3, incapacity for work due to sickness or injury, including any provisions for sick pay, and H, any special conditions of the contract. 6, the provision of this section in respect of written statement shall not apply if A, a worker has a written contract of employment which covers each of the particulars mentioned in subsection 1 of this section, and B, he has a copy of that written contract, unquote. The provision of the Labor Act captures super as it relates to an employee given written terms of contract is a mandatory provision in view of the operative word therein, id as quote and unquote shall, which connotes compulsion. As reason supra, the claimant in this case qualifies as a worker under the Act. The court have held that any employer who fails to give its employee a written statement of the terms of employment as prescribed in Section 7 of the Act is stopped from relying on the failure of the worker to tender his letter of employment in evidence. See the cases of Mobile Producing Nigeria Limited and another citation captured, Nwakoba and Dumes Nigeria Limited citation provided. It is also worthy of note that the defendant admitted by paragraph 1 of the statement of defense that claimant was its employee. Its only contention, however, is that the claimant is not a permanent staff, but a contract staff who occasionally work for the defendant. In view of the state of pleadings and the peculiar fact of this case, coupled with the ID card issued to the claimant by the defendant, I find that claimant is an employee of the defendant, even without tendering his letter of employment. It is the defense of the defendant that the claimant was not a permanent staff, but a contract staff who occasionally work for the defendant at different construction sites whenever the need arises and nothing more. Then counsel for the defendant has submitted that the claimant bears the burden to prove that he was a permanent staff of the defendant, and his failure to tender his letter of employment, which is supposed to show that is a permanent staff of the defendant, has made him unable to discharge the burden placed on him. It is the law that he who asserts a particular fact must prove the existence of such fact. See the case of Rubicon Properties and Developers Limited and another versus NACRDB, citation captured. The case of Omarioye and Assistant IG Zone 2 and others, citation captured. The defendant in this case, who is the one with the statutory obligation to issue claimant with the written terms of his employment, has failed in its statutory obligation, and it is equally the same person asserting that claimant is not a permanent staff, but a contract staff who worked for it occasionally. Claimant on his own part in this case has proven that is an employee of the defendant, and the onus has shifted to the defendant to disprove same by showing that claimant is a contract staff as alleged, and which it has to do by credible and cogent evidence. Until the defendant's assertion that claimant was a contract staff is proved, claimant cannot be called upon to disprove same. This is because the evidential burden in the case is static, is static, but shifts as the scale of evidence preponderates. See the case of Indul and Wayo and all the citation captured. The case of Ojo and Akisaoye, citation provided. The defendant has not substantiated its assertion that claimant was a contract staff with any credible, cogent, or reliable piece of evidence. Besides, the Supreme Court in the case of CIL Risk and Asset Management Limited and Ekiti State Government, citation captured, held that it is the duty of the court to enforce mandatory provisions of statute, and as such, the court is duty-bound to give effect to a legislation. The court went further that parties cannot, by failure to object or by acquiescence, nullify the effect of the statute. The statutory obligation imposed on the defendant to issue claimant with written terms of his employment, whether temporary or permanent employment, is mandatory, and defendant who failed to do so as mandated by the Act cannot be allowed to benefit from his own wrongdoing. In the absence of any credible, cogent, and reliable evidence in proof of the defendant's assertion that claimant was a contract staff, coupled with the defendant's failure to give claimant written terms of his employment, I disbelieve the defendant's assertion that claimant was a contract staff and not a permanent staff of the defendant. Consequently, I find that claimant was a permanent staff of the defendant. Before addressing the relief of the claimant, let me first state that it is a well-settled position of our judicial law that statement of claim herein called statement of facts supersedes the writ of summons, which is also in this court known as general form of complaint. See the cases of Salisu and Mobolaji, citation provided, the case of Ezenwa and Oko and other citation captured. Claimant, by his relief one in his general form of complaint, sought a relief thus, and I quote, the sum of 388,500 naira only as outstanding balance of his entitlement at Dubi site, Niger State in 2009, and Nakuse site, Nasarawa State in 2010. While in paragraph 12 of his statement of facts, he sought for, in relief one, thus, I quote, the sum of 388,500 naira only as outstanding balance of his entitlement at Nakuse site, Nasarawa State in 2010. There's a clear difference between both reliefs in the general form of complaint and the statement of facts, respectively. It is not the same relief that was sought in relief one in the general form of complaint that was sought for in relief one in paragraph 12 of the statement of fact. While one is as regards the balance of claimant's entitlement in Dubi State site, Niger State, and Nakuse site in Nasarawa State, though the amount are the same. In this instant, it is what is contained. It is what is contained in the statement of facts that will be considered as the statement of facts supersedes the general form of complaint. Claimant in his relief one in the statement of fact is seeking for the court to grant him the sum of 388,500 naira as outstanding balance of his entitlement at Nakuse site in 2010. There's no doubt that the above is in the realm of special damages that must be specifically pleaded with distinct particularity and strictly proved. See the case of Obey and MTN Nigeria Communications Limited, citation captured, Ajigbo Tosho and RCC, citation provided, Access Bank PLC, and Vicapec International Limited and another citation provided. The import of the above authorities is that full particulars of the items have to be given in the pleadings and evidence that in proof of each item or each of the particulars of the items given. In other words, a claim for special damages succeeds only on the straight proof of the specifically pleaded facts in relation to the sum claimed. It follows that where items of special damages are not specifically pleaded and strictly proved, the claim will fail. Claimant, by paragraph 10 of his statement of fact, gave particulars of the sum of 388,000 naira, just a minute. 388,500 naira claimed in relief 1. Claimant claims is as regards the outstanding balance of the statement of his entitlement at Nakuse site in 2010. The defendant, by his statement of defense, averred that he does not owe claimant the amount claimed, that he paid all his entitlements till 2014 when he last worked for the defendant and thereafter absconded. The statement of account relied on by claimant in this case covers the period of 2012 to 2017, and in respect of which claimant is not claiming any entitlement in relief 1 in the statement of facts. I've equally gone through the said statement of account, and I find that the salaries reflected in that statement of account are not the salaries disputed by claimant herein and claimed as balance in relief 1. Thus, the statement of account of claimant in this case is of no evidential value, as it has nothing to do with his relief 1 and the statement of fact, as it covers a period different from what he is claiming. I'm mindful of the fact that claimant pleaded his monthly salary as 54,500 naira monthly, and his support tendered his salary payment slips, showing the sum of 54,500 as his gross pay. However, from the said pay slip, claimant's net pay after several deductions, including taxes, is 48,450 naira. There's nothing before this court to show that claimant was short paid in respect of those sums claimed in the year 2010 at the Nakuse site as claimed in relief 1 in the statement of facts. Consequently, I hold that claimant has failed to prove relief 1. I so find and hold. Claimant in his relief 2 is praying for the sum of 415,000 naira as his entitlement retirement benefit or payoff after working for 14 years with the defendant. Claimant, by paragraph 11 of the statement of fact, averred that by virtue of working for the defendant for a period of 14 years and the period of stood off, is entitled to the payment of 415,000 naira as stated in the staff handbook of the defendant. The defendant, on his own part, in response to the said averment, by paragraphs 14 and 15 of its statement of defense, denied the said claim and stated specifically in response that claimant was not entitled to the said term and condition as same is only applicable to permanent staff of the defendant. First, I've held supra that the claimant is deemed a permanent staff of the defendant, as the defendant did not prove its assertion that claimant is not its permanent staff and can also not benefit from his own wrongdoing of failing to give claimant written terms of his employment as mandated by the Act. Thus, it is settled that claimant is entitled to the terms and conditions to benefit from the terms and conditions in the defendant's staff handbook, as the defendant has not placed any credible evidence is entitling claimant from same. Be that as it may, claimant in this case did not plead the particular provision of a said handbook that entitles him to the said sum as retirement benefits. I've however gone through the whole of the staff handbook, which is the condition of service, and I find at page 13 of the staff handbook, specifically by Article 25, a provision on retirement does, I quote, and on attaining the age 60, an employee's appointment will automatically terminate on ground of old age. If an employee has put in 10 years of continuous service, he or she may voluntarily retire or be retired by the company on after attaining 50 years of age. A, the following retirement benefit shall be paid. 1, for the period of 10 years of continuous employment, 100% of the last month's pay for each year of continuous service. 2, for the period of 11 to 20 years and above of continuous employment, 150% of the last month pay for each year of continuous service. 3, for the period of 21 years and above of continuous employment, 200% of the last month's pay for each year of the continuous period service. B, a notice of 3 months shall be given to an employee who is about to be retired by the company, and the befitting befitting sent forth party may be organized by the management, unquote. The above provision of Article 25 on the handbook is clear and requires no aid to understand. It is obvious from the above captured article of the staff handbook, which is also the condition of service of the defendant, that payment of retirement benefits to staff is not automatic. It is either the employee is retired by age, or he voluntarily retires after 10 years of continuous service upon attaining 50 years of age, and pursuant to which such employee would be paid retirement benefits based on his year of service and last pay. Claimant in this case, who wants the court to believe that he's entitled to retirement benefits after allegedly putting in 14 years of unbroken service, failed to show this court that he has voluntarily retired and that he has attained the age of 50 years for voluntary retirement as provided in the handbook. The law is well settled as reason supra that monetary claims are in the realm of special damages that must be specifically pleaded and strictly proved. See the case of B and MTN Nigeria Communication Limited Supra. Claimant in this case has tendered his payment of slip, showing how much he was paid last by the defendant. From the said payment slip, claimant gross salary is 54,500. However, claimant in this case has not strictly proven that he has voluntarily retired or has been retired by the defendant to be entitled to retirement benefits under the handbook, even though this court has found that the said handbook applies to him for reasons earlier given. In fact, claimant by paragraph 3 of his reply to the statement of defense averred that it was a stood-off that disengaged him in 2015. It is thus clear from the averment of claimant that the severance of his relationship with the defendant was not one of retirement, in which case he would be entitled to retirement benefit under the handbook as claimed in Relief 2, but as a result of a stood-off. In my view, the best claimant could claim under the handbook, even where it was shown that it was a stood-off that severed his relationship with the defendant, is redundancy benefits under the handbook, as provided in Article 13 of the handbook, if it is shown that the said stood-off, which is a species of redundancy. However, claimant by Relief 2 is claiming for retirement benefits. Besides, claimant who is claiming the specific sum of 415,000 naira as retirement benefits fails to plead with distinct particularity how it came by the quantum of the sum claimed as retirement benefit for 14 years of service as required by law. This is fatal to his case. See the decision of the Supreme Court in the case of Onyora and another citation captured, the case of Ayeni and CCECC Nigeria Limited citation captured. It is not enough for claimant to rely on the handbook in proof of his statement, in proof of his entitlement. He must of necessity plead how it came by the quantum of the sum claim by giving a breakdown of the number of years spent multiplied by his last salary as provided for in the handbook. This court cannot make its own assessment, excuse me, in the absence of specific particulars to how claimant came by the quantum of the sum claimed. The averment in paragraph 11 of the statement of fact as to the sum claim is speculative and incurably bad, having been arrived at the whims and fancies of the claimant without distinct particulars, therefore belonging to the realm of speculations which is not allowing law. In view of all the reasons given above, it is clear that claimant cannot succeed in his claim for retirement benefit of the sum of 415,000 naira. Hence, claimant's relief 2 also fails. Just a minute. The claimant, by his relief 3, is praying for the sum of 1 million naira as general damages. There's no doubt from the above that this relief is an ancillary one to the main reliefs above, which reliefs have failed. The position of the law on the effect of failure of main claims on the ancillary claim is clear. The court per Aliu JCA, in the case of McDonald Scientific Emporium Limited and Access Bank, citation captured, held us, and I quote, failure to prove the main declaratory relief sought means the ancillary reliefs of damages have no basis because damages cannot be awarded in vacuum. The lower court rightly disregarded them also, unquote. See also the case of Fafunwa and Bellevue Travels Limited, citation captured. Claimant in this case have failed to prove his entitlement to the sum claim as special damages in reliefs 1 and 2, and as such, the relief for damages cannot be granted in vacuum, having not shown that that he was entitled and wrongly denied by the defendant. This is because one cannot put something on nothing and expect it to stand. Therefore, relief 3 equally fails. The second issue framed by the court is as regards the counterclaim set up by the defendant. The law is well established that a counterclaim is a separate and independent action, which is usually appended to the main or principal claim for convenience of determination. See the case of Faluyo and Faluyo, citation captured. The counterclaim being a separate and independent action, the counterclaimant, like a claimant in the main action, must prove his case against the defendant to the counterclaim. See the case of Think Ventures Limited and Spice and Regular, citation captured. The case of NBC PLC and ECHO, citation provided. Delta Air Services Limited and Sudan Airways, citation provided. The counterclaimant in relief 1 in the counterclaim is asking for the last month P of 54,000 naira covering the month of October 2014, erroneously, according to them, paid to the claimant who was no longer in the employment of the defendant. The defendant counterclaimant asserted that the claimant was not among those stood off as he absconded from the defendant's employment in September 2014 and have never been seen to date. It's averment that claimant defendant to counterclaim was not entitled to the salary received in October 2014, as the sum was paid in error by the account department. Claimant in response by paragraphs 4 to 10 of his defense to the counterclaim refuted this claim and maintained that he was not paid in error as alleged by the counterclaimant. By the provisions of section 1311 of the Evidence Act, whoever desires any court to give judgment as to any legal right or liability dependent on the evidence of fact which he has said shall prove that those facts exist. Besides, it is clear as reason supra that he who has said must prove as reason must proved. See the case of Rubicon Properties and Developers Limited and another versus NACR DB Limited Supra. Also in the case of Bamigbegmi and others versus Zuriare and other citation captured, Muhammad GSC held us, and I quote, in a civil action where there is an overwhelming evidence in proof of the claim before the trial court, plaintiff will have discharged the onus of proof placed upon him by law, where he puts sufficient evidence in support of his claim, unquote. Thus, the counterclaimant bears the onus of proving that the claimant was not entitled to the said salary received in October 2014 having absconded from work by placing sufficient evidence before the court. The defendant who has these onus has failed to discharge these onus by placing before the court credible and cogent evidence or document showing claimant absconded from work and that he did not work for it in the month of October 2014. The defendant who would want the court to believe that claimant did not work for it but absconded since 2014 has not proven this accession. Hence, the onus will not move to the claimant or defendant to counterclaim. There's therefore nothing for the defendant to counterclaim to disprove. The only reasonable conclusion to be drawn, unless otherwise controverted by equally credible and cogent evidence, is that claimant defendant to the counterclaim, having been paid for October 2014 by the defendant, the counterclaimant has earned same by working for the defendant counterclaimant. The counterclaimant has the option of shifting the burden of proof by adducing cogent, concrete, and credible evidence to show as alleged that claimant defendant to counterclaim absconded from work and as such was not entitled to the said salary was paid in October 2014. In view of all reasons supra, I find that counterclaimant is not entitled to relief A in the counterclaim. Thus, relief A or 1 in the counterclaim fails. The defendant to the counterclaimant is also claiming the sum of 500,000 naira as damages for the period the money stayed with the claimant, which could have been effectively utilized to yield more than the said 500,000. This particular relief is also ancillary to relief 1 in the counterclaim, and as reason supra, where main claim fails, the ancillary relief must equally fail, as you cannot put something on nothing. See the case of McDonald's Scientific Emporium Limited and Access Bank Supra. In view of the failure of the counterclaimant to prove that the claimant was not entitled to the said salary received, court cannot award any damages to the counterclaimant. In view of this, the said relief on damages equally fails. In sum, I find and declare as follows. 1, that claimant's action fails in its entirety. 2, the counterclaim of the defendant counterclaimant equally fails. 3, parties are to bear their respective costs. Judgment is accordingly entered.
As God pleases. My Lord, we are most grateful to the court.
Parties are entitled to a copy of the judgment, which will be sent to your Lokoja. Call the next case.
Please.
By NICN LKJ 13/2021 between George Adamu and Bulletin Construction Company Limited. Claimant is in court, my lord. Defendant absent.
Appearances.
May it please me, Lord, I'm P. I appear for the claimant, sir.
Any other appearance? Any other appearance?
Newly in the court here.
Online, Mr. Damian. I can see Damian, but I can't hear his voice. Okay. Mr. Ame. Mr. Ame.
My Lord.
Yes, since the facts of this case are the same.
Yes, my Lord.
I will just read the summary of this judgment and you will get a clean copy.
As God pleases.
Also in view of the fact that we don't even have light here. So I'll just read the summary of the judgment. You have a copy, clean copy. In sum, I find that claimant has failed to prove his claim, and as such, his case is liable to dismiss. Accordingly, claimant's case is hereby dismissed. Parties are to bear their costs. Judgment is accordingly entered.
Court please.
So I will send the copy of the judgment for you to have your own clean copy.
As God pleases. We are most grateful to me, Lord.
Very well. Take. I learned there is one Lokoja matter.
Yes, my Lord.
Go ahead and call it.
By NICN LKJ 2022 between Sally Hudele and Ajokuta Company Limited. Judgment creditor is in court, my Lord. The judgment date of absence.
Appearances. Who is in court? Who is in court? I have counsels waiting for me in Abuja.
Please, my Lord. Idigbe is my name.
Unmute your phone.
Idigbe is my name, Lord. Idigbe is my name. The Lord, we are ordinarily not parties to this proceedings, but we have interested party regarding the order of the court that was made against Union Bank. To that extent, we have application.
You are parties interested and you have not filed any process, have you?
We have an application, my Lord, in the application of Property Consulting Limited.
In the application of what?
In the application of Property Consult Limited.
When did you file the application?
On the 30th of March 2023, and served the judgment creditor and the garnishee. This morning we received the counter affidavit and the written address in support of same by the judgment creditor.
Mr. Who is for the judgment creditor?
Just 13 now.
My Lord, Ido
Any other appearance?
May it please my Lord, I am GF Kolawole for the 13th Ghanaian. That is everything I have, my Lord.
Zenith Bank. Heritage.
Yes, my Lord.
Any other appearance?
May you please me, Lord. I am CS.
Sorry?
My appearance. CN
CM.
CN. And my appearance is for the 14th Ghanaian.
FCMB.
FCMB, yes.
Any other appearance? Okay, actually, it's only the 13th and 14th Ghanishis that I said. So have you filed the affidavit to show cause?
Yes, my Lord. The 13th Ghanaian have filed.
When was it filed?
My Lord, it's on the 8th of February 2023. It was filed on the 8th of February 2023.
8th February.
Yes, my Lord. Yes, my Lord.
February 8th.
Yes, my Lord. Yes, my Lord.
Okay. So what is in there?
Yes, my Lord. In pursuant to the Ghanaian order issued by this honorable court on the 13th day of December. My Lord, the 13th Ghanaian carried out a thorough and search of its database and that of all its customers and account holders. And it was discovered that the judgment debtor does not have an account.
Very well.
With the 13th Ghanaian. And that is why we have filed this affidavit, my Lord. My Lord, we also attached a written address to support him. My Lord, we also attached a written address to support him.
Very well. 14th Ghanaian. Have you filed an affidavit to show cause? Unmute your phone.
My Lord, we are served hearing notice on the 18th of April. We were never served the other list.
You were never served with the other night side.
Yes, the other night. It was on the 18th we were served with. a hearing notice. As to that
So you have
behavior.
not filed any affidavit to show cause?
The instruction was that we can't file this morning until after sitting.
Court registrar, confirm whether or not you serve the other NISI on the 14th Ganishi, First City Monument Bank.
My lord, they were served and proved. It's filed, is in the case file there, my lord. My lord, sir. Don't have anything.
Court registrar, come and check for me if there was any proof. Come and get the file. Check if there is any proof of service on the 14th Ganishi with the order NISI.
Copy this here.
Please mute your phone. Mr. Adejuma, whilst we are waiting for the court registrar to produce the proof of service on the 14th Ganishi, are you in receipt of the process filed by Union Bank?
Yes, my lord, I received it, my lord, and I also reacted.
It's not Union Bank that fights. But it's that the application is not at the instance of Union Bank, but at the instance of persons whose interest in the account that was garnished. ProQuest, my lord.
ProQuest.
ProQuest Property Consult Limited, my lord.
Well, Mr. Adejuma, have you filed a reaction to it?
Yes, my lord. I have found the reaction. I found the reaction, my lord.
When did you file?
We found the counter, my lord, and the written address.
When did you file it?
We filed April.
14th of April.
14th of April.
Yes, my lord.
Mr. Idigbe, are you in receipt of that?
14th day of April.
Yes,
are you in receipt of the response?
At about 9:45 a.m. this morning, I was served. Yes, my lord. At about 9:45 a.m. this morning, I was served with the address and counter affidavit.
So it's right for hearing.
No, we need to respond. We need for us to, considering that we have gone through same, considering the facts stated there, we require time a lot to file the further affidavit and reply on point of law.
Okay.
Yes, my lord. In the circumstance of waiving your indulgence for another day to enable us to react to the counter affidavit and written address in support of suit.
Mr. Omesiobu.
Yes, your lordship.
There is a proof of service of the enrollment of the order on your client, the 14th Ganishia CMB. And it was served on them, they received it. We have their receipt stamp. FCMB PLC, Lokoja, CSO, was received on 23rd of December at 11:09 a.m. So they received it. So you have to file your affidavit to show cause.
Yes, your lordship, we do that. immediately after the sitting. But we, however, have the affidavit here.
Eh?
We have the affidavit.
You have filed it.
No, we have not filed yet. The court register says until after the sitting.
Okay, so go and file and serve a copy on Mr. Adejuma, the Judgment Creditors Council.
My lord, the judgment debtor,
yes,
although maintains an account with us, but they are.
You can't talk about what you have not filed and served. So file it and then serve on the Judgment Creditors Council so that by the next adjourn date, you'll be able to talk to it. So what date?
May. 24th May. 24th May is not convenient for me, my lord.
What date?
It's not convenient to me. I have a 25th is not convenient to me. I have me tell him. First or 21st?
21.
Okay.
My lord. May we have one that the 13th Ganesh be discharged, my lord.
Very well.
Most grateful, my lord.
What date, court registrar? 20 what?
21.
Okay.
My lord.
Who?
The seventh.
The 7th Ganeshi.
Yes, my lord.
Okay, 13th Ganeshi is discharged, while the 7th and 14th Ganeshis are to file the affidavit to show cause. The party interested is equally to file a reply to the counter affidavit. Case adjourned to 21/6/2023 for continuation. So serve hearing notice on the 7th Ganeshi. Is that all in Lokoja?
Yes, my lord.
Arise from Lokoja.
I don't sign up.